So by the term Sharia, we try to understand that Islamic law is known as Sharia. So Islamic law influences our every aspect of life, and it is a kind of comprehensive law, and it does not tell us only how we will be responsible to our theater. It also makes us responsible about the dealings what we do with other people in the society. And the question is, who is bearing the responsibility as a trustee for this Sharia court? Who has taken the responsibility that it will be the Sharia law will be maintained properly, and it will not be violated, or it will not be changed, or it will not be moderated, or there will be no fabrication of this Sharia law. So who has given the responsibility? So global Muslim community in the term of Ummah has given this responsibility. So it is said that Muslim Ummah serves as a trustee for upholding the Sharia law. So what Muslim community can do with the Sharia law? What can they do, what they cannot do? So Muslim population live across the world. So from the Sharia law, they can develop the rules applicable for them or derive rules applicable for them, but they cannot create any law and instill it in the Sharia law. But every Muslim has the responsibility, or has the discretion, or has the right to interpret the Sharia law. But when there is a clear command, or there is a clear instruction from Allah or his prophet, no one, absolutely no one, has the authority to change, to modify, or to advance, or to prejudice the Sharia law. So that's why you see the same Sharia law is applicable to all Muslim countries. There is no difference from country to country. So what is the purpose of Sharia law? The purpose of Sharia law is to make sure that the human beings adopt what is good, what is just, what is beneficial, and what is essential to build a moral society. And Muslim people also, for the Sharia law, they avoid any harmful thing or anything which has been restricted to them, which might become which might become which will not be good for them in long run. So Sharia law can be broadly classified into two groups or two ways. some laws or some jurisprudence includes those rulings which define the relationship of man with his creator. This classification is known as Ibadat, and there is another classification which encompasses the rulings which is applicable for the man relationship with another man or with other men. And this classification is known as Muamalat. So we'll know more about this in our class today. That and our interest is on the discussion of Muamalat rather than Ibadat. And because the Islamic finance and Islamic banking requires commercial dealings, it requires the economic transactions, activities, and all these things are part of Muamalat. So these things are part of Muamalat rather than Ibadat. So you have learned that Muamalat encompasses those rulings which deals with the way of relationship between man with another man. So which things we will try to cover today? One part you already have learned, that we'll try to understand the Sharia law and what are the sources of Sharia law, and what are the primary sources and what are the secondary sources, and where or in which countries there is national Sharia board, and what is the work areas of the Sharia board, and how Sharia scholars in Sharia board are appointed, and how they should conduct meeting, and which institutions are in responsibility to approve new products, new services of Islamic finance and banking, and how they control or how they check the accounting activities, or how they make a Sharia audit, and if there is any guiding authority, who are the guiding authority in global scale. So you look for these things. So first of all, we already have mentioned what is about Sharia, and it provides us divine guidance, and I already have mentioned it is a comprehensive code of life. That's why it also encompasses the economic issues we deal in our real life. So the economic activities, I mentioned that these are part of Muamalat, and the Muamalat or part of the Sharia, how these are related to Islamic finance and banking, because the Muamalat part of the Sharia provides us what should be the legal framework, what should be the rules, what should be the conditions applicable for Islamic finance. And this kind of knowledge of Sharia, to learn about the Muamalat is very essential, and we need to learn about these things to understand that which are permissible, which are not permissible according to Sharia law. So before we already have explored some permissible Sharia compliant products and some conditions or some reasons for which the conventional products are not Sharia permissible. So from where we have got these things, or based on which we have concluded that these things are Sharia compliant or these things are not Sharia compliant. So primarily, the Sharia law is guiding us. So, but Sharia law is derived from which sources? So there are primarily there are two sources of Sharia law. So it was mentioned in the very first class that the primary sources of Sharia law are the Quran and Hadith. So you know very well that Quran is the direct word of Allah, and it was revealed to his prophet Muhammad, and during his lifetime of Prophet Muhammad, the Quran was recorded in written form, and there is no question on the guidance made by Quran, and it was memorized on that on that time. It was memorized by many people, and it is still this trend has been continuing for 1,000 years. So, and we are much familiar with this source. So it provides us the economic, it provides us the things which help us to learn what is justifiable, what is right, and what is not right. And to support the Quran, we have a hadith, and hadith includes all sayings of the Prophet, also his practices, his conducts, and also the things which he approved. However, the hadith was not recorded during the lifetime of Prophet because there was a likelihood that it will be mixed up or it will become confused with the Quran. That's why Sunnah or Hadith was recorded later after the departure of Prophet. So by this time, after the departure of Prophet, Hadith was recorded, and there was some fabricated Hadith, of which authenticity was not couldn't be validated. That's why those Hadith were discarded. So these things happened. I mean, these things started, the practice of Quran and Hadith started around 1500 years ago. So by over the this over the passage of this long period, there has been enormous changes in the Islamic society. Islamic society has faced new situations, uh, new issues, new complexities, and to deal with those things based on the Quran and Hadith has become complicated over time. That's why uh, the experts on the Quran and experts on the Hadith, they try to expand the interpretation of Quran and Hadith to understand and to provide the solutions to the new situations or new issues. And these things and these interpretations have been covered in the fiqh, and this fiqh provides the detailed coverage of the issues, which not only include regarding the muamalat, these issues, commerce, finance, taxation, inheritance law, these issues have been explained in detail with the interpretation from the Quran and Hadith by the scholars. So what I was mentioning that the fiqh law or the fiqh jurisprudence, which was initiated after Quran and Hadith for the clear interpretation, there has also been time pass. Long time was passed, and it has been observed in many Muslim countries that they are not following the Islamic law. Rather, they have initiated their own law, and they have initiated their own jurisdiction. That's why it became much more challenging. And at the same time, the scholars who initiated the fiqh primarily, they are not present, and they are not present on that time when the new situation came into existence. So that's why the challenges increased, that how the new issues can be dealt with the interpretation of Quran and Hadith. So new problems need to have solutions. So how can we provide solution? So there has been a practice which is named as ijtihad. So this practice, ijtihad, is a practice of expanding or elaborating the Sharia law. So how it is possible? It is possible because the scholars provide some individual interpretation, and there should be acceptance of this interpretation by a group of people, that it is accepted. This group of people must not be majority, but this group of people must be the scholars, and this group of people, the they should have knowledge of Sharia, and the knowledge of Sharia is also known as the fiqh, and the people who are experts in knowledge of Sharia and fiqh, and they are known as fuqaha, ulama, or Islamic jurists or Islamic scholars, whatever the name you used. Or so we need to check that what do we exactly mean by ijtihad, how it is possible to expand the Sharia law by making elaboration or by making expansion. So ijtihad is a practice by which we make a deduction or deducive process. And deduction from what? Or deducive, this practice makes some exercise that this situation or solution to this situation can be deduced from the interpretation of Quran or interpretation of Hadith. And this is a kind of independent interpretation by a scholar. And it might be a situation which has not been faced by the human beings earlier in the time. So based on the existing interpretation of Quran and Hadith, this reasoning is made. And did you see this term is meant that there is an interpretation and provide some ground of the existing situation, which on which apparently it might be the case that this situation cannot be solved by the interpretation, by the existing interpretation. It is the Quran and there is existing interpretation, and on the situation which is new, it might be apparent on the first sight that this situation, as this situation is new, this situation cannot be guided by the existing interpretation of Quran. That's why, but what is ijtihad? In ijtihad, based on the understanding of this whole condition or whole background of this condition, this interpretation is elaborated to deal with this new situation. And this interpretation should not come from any person other than Islamic scholar. And who is Islamic scholar? Who has knowledge on Islamic fiqh. And Islamic fiqh includes the thing which are Sharia law. So in that way, a number of situations which we face today have been resolved by the concept of ijtihad. And second one is ikhtiyar or choice, and ijtihad is reasonable, is synonymous as reasoning, and ikhtiyar is synonymous as choice. So if we face a new situation and we do not know how to deal with the situation, and the existing scholars cannot provide the interpretation of this, what can they do? They can select a past scholar and look at his or her views on that. So for example, there has been an example that for settling debt, that you have a debt you like to settle. Now, if the money what you will be using for settling debt comes from some non-permissible sources or doubtful sources, is it permissible or is it acceptable? In that case, you can look at the views of any scholar who is not present today. So what he or what was his thought? So this term is known as ikhtiyar or choice. So that you have selected a particular scholar's view. And you will see that there is a practice of these things. And the final one is durura or necessity. So sometimes we see that for the purpose of necessity, it is permissible to relax some conditions or to relax some bindings. So it is just based on the necessity. And if there is no necessity, it should not be done. But if there is necessity, in that case, this relaxation can be made on temporary basis. You probably know that if there is no other alternative, to halal food, I mean, if you do not have any halal food available, but you are extremely hungry, in that case, it is permissible to consume haram food only to meet your demand on that point of time. But so what we are doing there, we are doing some relaxation, but it is not applicable in other cases. So we just have given this example to understand that these situations might arise in Islamic finance and banking issues, that there is no other scope, that you are in a position that you do not have the scope. In that case, some relaxation, not full relaxation, a little extent of relaxation is allowable. So we like to concentrate on two issues. Basically one issue, that is hila or legal artifice. There is a practice of legal artifice. So what is the practice of legal artifice? Legal artifice is a practice of doing something which actually is a trick, and it is a activity of a clever person, and very clever person. Why he or she is doing this? He or she is doing this to circumvent the Islamic Islamic Sharia law, or to circumvent the Sharia guidance or Sharia law. Actually, it's not Sharia guidance, it is actually Sharia law. But the way he or she is circumventing Sharia law, that way is legal. That kind of practice is known as legal artifice or hila. Not hila, it is hila. So what are the ways how people do this? You probably have learned about waqfa from the class, from the previous class. Can you recall that we mentioned that how much proportion of your wealth can be bequeathed or can be given in waqfa? Can anyone recall? That is it possible that you make waqfa of all of your wealth? Is it permissible in Sharia? Are you there?
No, sir, not permissible.
Okay, fine. So for example, you are some person, or you are the person who wants to uh, deprive the your heirs from enjoying your property. So some people may engage in giving waqf of his properties for the purpose of uh, disobeying the inheritance law which has been uh, given in Sharia. So the law of inheritance is a very strict, that it has mentioned that which heirs of you are eligible to receive your property and which people are not eligible. And out of the eligible people, how much of the proportion of each individual will be is very clearly specified, and there is no confusion. But to circumvent this inheritance procedure, some people may engage in establishing a waqf and give away his total property in a way so that the person or the heir will be deprived of the property. So there was a practice of these things. So this kind of practice is known as hila, and sometimes it is observed that it does not break the rules of Sharia, but technically it does not. It is not in a conflicting position with the Sharia, but the way or the purpose for which he or she is doing this is not the good thing. So we have learned 3 ways of legal elaboration of the Quran and Hadith. So these things are ijtihad, ikhtiyar, and durura. So we have mentioned that ijtihad is based on making some deductive reasoning from the existing interpretation of Quran and Hadith. And in ikhtiyar, what we do, we select a view of a past scholar and try to apply this on the new situation. And based on the durura, what we do, we make some relaxation of the conditions of the rulings when it is necessary, based on the necessity. So here we like to look at 2 other sources of Sharia law which have been established based on the ijtihad what we mentioned earlier. So first one is Ijma, second one is Quias. So what we do in Ijma, so it is a very old practice that Islamic scholars debate. And this situation was also prevailing during the Prophet time. There was a debate on how this situation can be solved or how this problem can be solved. And also, so what is the point here? The debate continued, and the debate is still has been continued. So Islamic scholars provide opinion on the Sharia issues based on Quran and Hadith. Now, exactly that problem might not be solvable using the guidance provided by Quran and Hadith, but based on the Quran and Hadith, some or partial interpretation can be made. So the scholars provide ijtihad, and this practice, the ijma, started during this period, during the period of the first and second Khalifa. So this debate, when there was a acceptance by the jurist that they collectively accept this interpretation, in that case, that thing is accepted by mean of ijma. But there might be some situation where there is no collective consensus or no collective consensus has been reached. In that case, what was the practice? The practice was that Khalifa pick that opinion or that interpretation which seems to be most beneficial for the interest of the public. Now the practice is this ijma was applicable on the time when there was a period of these people, Sahabi, and after their period there was a period of Tabi, and after that period there was a period of Tabi Tabin. In those three periods, the ijma was very much acceptable because those time are known as the time for truth and the year of truth, because after that, after these three periods, there has been a number of fabrications, and the true spirit of the ijma no longer exists. So that's why ijma is not well accepted, or ijma is not clearly applicable nowadays. And there are some rulings applicable for ijma, that how ijma should be made. So one thing is very clear, that ijma, anything which is accepted as based on the ijma, by no means should contradict with the Quran and Hadith. And it is not something that ijma is something that where most people have consensus. It is not such thing. Ijma is such thing where most Islamic scholars have agreed, and it is in compliance with the Quran and Hadith clear interpretation. And the next thing, next source of Sharia law, which is also secondary source, is the Quias, and it is also the practice of ijtihad, and it is a kind of individual practice and individual deductive reasoning. So, for example, there was a case interpreted in Quran or Hadith. And right now you are in a new case, but apparently it is not possible to compare this new case with the case mentioned in the Quran and Hadith. But there are some characteristics which are similar between these two cases. In that case, you can follow this case and how it was resolved to solve the issue of this new case. So Qias is something which is by the term is known as comparing or estimating one thing against another. So these are four primary sources of Sharia law, what we mentioned, and these are in practice to guide the Islamic finance and banking issues. Now the question is, in the national level, there is a practice of Sharia board who are in charge of looking after the issues which are arising are in compliance with the sources of Sharia law. We just have mentioned the sources of Sharia law, and Sharia board is in charge of the responsibility to make sure that all the dealings of Islamic finance and banking institutions or authority or market are in full compliance with the guidance, rulings applicable from the Sharia sources which we just have mentioned. Okay. So in some countries, there is a practice that they have a central Sharia board. So in Malaysia, the central Sharia board serves directly to the central bank. But in addition to the Sharia board of the central bank, the Securities and Exchange Commission also has their own Sharia board. And only these national boards have the authority to issue fatwa. So you might ask that what is fatwa here? So fatwa is something which is a kind of interpretation made by Islamic scholar based on the sources of Sharia law and is approved by some recognized Sharia scholar. It is not a kind of individual interpretation, and it is being issued or it is being circulated. Obviously, usually what is the practice that one individual scholar issues the interpretation of some issue or some question and how it can be solved, and there should be some clear references, clear deductive reasoning from the Quran and Hadith. I mean, how he or she has made the ijtihad, and then it should be verified and it should be approved by some recognized 2 or 3 recognized Islamic scholars. So in Malaysia, the authority of issuing fatwa is only with these 2 national boards. One board is with the Securities and Exchange Commission and another board is with the central bank. And in Sudan, it has been said that finance specialists and economists serve on the Sharia board of the central bank as well as fiqh scholars. Okay. And Iran, there is a practice that the Islamic banks, their banks operate under this law on usury or high interest or interest, simply interest-free banking of 1983. And this was approved by the highest political and religious authority of Iran. And there is a council who has the authority on fiqh. But what is the practice of Bangladesh? In Bangladesh, it is a kind of more decentralized. We'll talk about it more later. But in Bangladesh, there is a central Sharia board for Islamic banks in Bangladesh, CSBIB. So it was formed by the Islamic banks and financial Islamic banks, particularly Islamic banks in Bangladesh, and the initiative was taken by the central bank. And what is the responsibility of this body? This responsibility of this body is to make a coordination among all the individual Sharia board who work in the individual Islamic banks for the supervision, and also do research works on Islamic finance and banking issues. So, are you aware of this authority? Central Sharia Board of Islamic Banks in Bangladesh? Islamic banks in Bangladesh, anyone? We have two people working for Islamic banks in our class. Are you aware of this board? Central board?
Yes, sir.
Fine. So you can go to their site, and they provide the activity, they provide the listing of the activities, what they do, and who are the members of this board, these things. Okay. Now, what I mentioned earlier, that there's a practice that the government is trying to make a decentralization of the Sharia compliance task. That government is not in a position to make a body, a centralized body, and that will look after the Sharia compliance of all institutions. Rather, government is more interested to decentralize the task of checking that individual bank and financial institution is complying with the Sharia. So that's why at every institutional level, commonly we have a Sharia board, you will see, and Islamic financial institution individually appoint their own Sharia board. And there is this practice we mentioned here, that privatization of Sharia compliance rather than nationalization of Sharia compliance. But it is desirable that you make nationalization of Sharia compliance rather than making privatization. So when you are making the privatization of Sharia compliance, more issues will arise, more debate will arise, more non-compliance will arise, which might not be possible to check by you. You mean you are a regulatory authority. So that's why there is a issue of conflicts, and I do not know and I have not seen that individual Sharia board of individual Islamic banks in our country is approved by central bank or not. I have not seen such thing that central bank has taken the authority that I will approve your Sharia board or not. Rather, I probably have seen that the board, I mean the Islamic financial institution or Islamic bank themselves are responsible for forming their Sharia board, and they approve the individuals who will be the member of their Sharia board. There is some guidance. Obviously, there are some guidance from the Bangladesh Bank regarding the criteria of individual who will be the member of Islamic, I mean Sharia Supervisory Board. It is a specific Sharia Supervisory Board. So I will show you those guidelines from the Bangladesh Bank. I probably have mentioned that guidance on the previous class when we were discussing the Bangladesh Bank guidelines for Islamic banking. And there is a mentioning of annexure. I will show you the annexure in today's class. Okay. And in other jurisdictions, there is no system that they make a national level approval of the individual Sharia board. And there are some consideration in some countries that will do some approval of the Sharia board on a national level. So Islamic faith, and the next thing that Islamic faith is nowadays can be classified into two groups. So one group or one division is known as Sunni, and another division is known as Shia. Within each division, each broad division, there are some subdivisions based on their faith. And these divisions have a good number of similarities. At the same time, they have a good number of dissimilarities. But how the individuals or Muslim community follows the Sharia interpretations or fiqh interpretations. I mean, fiqh is the interpretation of Quran and Hadith. There are four schools. There are four schools for what? There are four schools for classifying the way that how Muslim community follow the Sharia interpretations. And there are four schools of thought. You can say alternatively four schools of interpretations. There is no conflict. There is no conflict. They complement each other, and there is no superiority of each school over another school. And one individual is entitled or is empowered, is free to follow any of the thoughts of any school. So try to look at which are these four schools. So there are four Sunni schools of thought. So one school of thought is, the first one is Hanafi. First one means here that it was introduced first at the very inception of this kind of practice, which was followed for long 600 years. Probably you know that Ottoman and Mughal Empire, and these two empires rule for long years. So you can understand that for how many years that this practice has been continued. So what is the actual fact of this Hanafi school? So actual fact of Hanafi school is that they examine the Quran and the Sunnah to make the judgment or to extrapolate, and extrapolate is similar to the word we mentioned, the deductive, we mentioned the ijtihad. This is these are the similar words. Judgment based on this for a particular case, and this approach is mentioned as deductive approach. And now in which countries there is a practice of this Hanafi, or in which countries the followers of Hanafi are live most. So it has been mentioned that it was originated in Iraq, but the practice is followed in Turkey, Pakistan, India, Bangladesh, Afghanistan, Lebanon, Central Asia, parts of Iraq, and also part of Egypt. And the next one is Maliki. And in Maliki, they draw you see that their basis, they make deductive reasoning based on the Quran and Sunnah. And in Maliki, they look at the experiences of the people of Medina and respects of local customary laws, provided it is not conflict with Quran and Sunnah. So you can understand that there might be some practices or some experiences of Medina which are not in conflict with Quran and Sunnah, but not necessarily are mentioned in Quran and Sunnah, or not in clear conflict with Quran and Sunnah. In that case, they accepted those. And it is widespread in this region, North and West Africa, and specifically in terms of country in Middle East, UAE, then Kuwait, then Saudi Arabia, parts of Saudi Arabia, and also part of Egypt. And especially North and West Africa, the Maliki school of thought is followed by many people, many Muslim community. And it has been mentioned, you probably have heard about the civil law and common law. And it has been mentioned that Maliki school of thought is very closest to the English common law. And there are two other school of thoughts you probably have heard about. And we mentioned the Hanbali. And this Hanbali is, you see that strict adherence. And you see how this is different from Hanafi and Shafi, how their approach is different. A strict adherence to the Quran and Sunnah, stressed, and if possible, avoided any analogical deduction. So this flexibility is discouraged in the Hanbali. And they also try to classify the hadith into weak and sound basis based on their perceived authenticity. Their perceived authenticity. So they have classified into weak and sound basis. So there is a debate that can you ignore this weak basis? Can you ignore any hadith which has weak basis? So there are so many hadith which we apply, or so many sunnah we apply in our regular life, and we have been applying it with good belief. but because of the situation, because of the context of the interpretation of that hadith, there might be a fewer people, fewer companion of prophet. That's why the evidence is weak. But is it allowable, is it permissible that you have ignored any hadith because the evidence of this hadith is weak, or number of people or number of companion who mentioned or who described this hadith is few? So that's why there is a issue on this, that can you ignore this? Okay, we already have mentioned that remember, weak hadith is different from fabricated hadith. So these two things are different. So there are some people who try to mention that weak hadith are fabricated hadith. This is not such thing. Fabricated hadith is different thing, and fabricated the hadiths which were fabricated have already been most of those hadiths were dismissed during the period of Umar ibn Abdul Aziz. You probably have heard about this ruler. Okay, so whatever, and it has been mentioned that this humbly is most restrictive approach to Islamic finance. Most restrictive approach to Islamic finance. So that's why what is expected? It is expected that the country where the humbly school of thought is followed, which countries? The countries, parts of Iraq, Syria, Qatar, and most of Saudi Arabia, you should expect that their Islamic finance is more, their Islamic finance follows most restrictive approach. It is expected. The practice might be different, but it is expected that their approach to Islamic finance is most restrictive. And the final one is Shafi, and Shafi is this practice is more liberal regarding the financial matters. So you see that it is most restrictive and it is more liberal. And this Shafi school is dominant school in Southeast Asia. However, there is a practice of Shafi school of thought in countries like Indonesia, Malaysia, Brunei, Philippines, Singapore, Thailand, parts of Egypt, Jordan, Palestine, Yemen, Somalia. The Muslim community in these countries adhere to this school of thought, Shafi. And they have mentioned two finance product, I mean specifically refinance product that allows the seller of an asset to buy it later at a higher price from the buyer of the asset, from the original buyer of the asset. So it has been given permissibility in the Shafi, and also the sale of debt permissible provided it is not discounted. Okay, there is a question. You probably have we probably have discussed about it in Shukuk. So there is a question: is Shukuk is tradable or not? So there are some opinions that Shukuk or Islamic securities, Islamic financial securities should not be tradable. There are some reasons. I am not mentioning those reasons. And some scholars have provided the ground that the Islamic financial securities are also tradable. So there are some conditions when it is tradable or when it is not tradable. So you see that Shafi is flexible on the guidance that Islamic debt-based security, Islamic debt-based security, and you probably have learned that Shukuk is one of those securities which is debt-based, not absolutely debt-based. There is a mixture of equity and debt, so it is permissible to trade. And the last one is Shia, and it has been observed that the Islamic financial practice of the Shia school is not significantly different from the Sunni schools of thought, which we have mentioned, that Hanafi, Maliki, Hanbali, and Shafi'i. So we'll take a break, and next we'll talk about the Sharia board. Okay, I already mentioned about Sharia board practice, and there is an existence of Sharia board in each financial institution. So already have mentioned what is their responsibility, what they do. So their activities are like the activities of consultant, and their activities can also be compared like an activity of auditor. They make a Sharia audit, and they give warning when their management is doing something which is in violation of Sharia. So sometimes they need to issue fatwa when it is necessary, but that means their management services and products should be approved by the Sharia, by the Sharia board. So when they approved, they provide the credible evidence, and they provide the deductive reasoning. So these things bring some fatwas which are followed by the management. And if we consider Islamic bank as Islamic financial institutions, they provide the full-fledged services, not only deposit services or only investment services or only some issuance services like investment bank. If they provide full-fledged services, in that case, it is usual practice that their Sharia board is comprised of 5 or more scholars. And if any conventional bank, you probably have learned from earlier class that our conventional banks are introducing Islamic banking operation by opening a separate window or separate branches, naming Islamic banking branch or Islamic bank window. In that case, they also have to form Sharia board, and their Sharia board may comprise of 3 scholars. And if there is an absence of Islamic Sharia board, what can they do? They can outsource the Sharia board by the assistance of some institutions, or also they can avoid the requirement of Sharia board. It is not possible in case of Islamic banks or Islamic financial. For some Islamic financial institutions, it is possible, say, if you are someone who is making some passive investment, or who is making some index investment, in that case, the requirement of Sharia board can be compromised. So one such practice is that if you follow the Dow Jones Islamic indices, In that case, you can do this. And you can also, there is a practice that your mutual fund has no Islamic, your mutual fund is a Sharia fund, but you do not have the in-house Sharia board or Sharia supervisory board. In that case, what can you do? You can outsource these activities, or you can outsource the Sharia board from some private entities. So I already have mentioned the point that this is checked in individual level. Institutional compliance is checked rather than checking from national level. So when there is a presence of Sharia board, usually Sharia board line of control, in the line of control, Sharia board is in a position on the top of board of directors or internal Sharia audit and of the clients. So they oversee and they guide the board of directors and internal Sharia audit. And they also look after the activities, and if there is any product management wants to introduce, but there should be some clear approval from the Sharia board that this can be floated or this cannot be floated. So if Sharia scholars make audit, audit here is not an accounting audit. Audit here means you are doing a Sharia audit. So you can easily understand that your check is to check that whether the practices and activities of Islamic bank or financial institutions are in compliance with the Sharia rulings. And if there is any qualitative opinion from the Sharia board, in that case, management has to check and management has to revise the terms of the product or terms of the services. And there is also possible that these audit activities can be external or can be internal. And some activities can also be outsourced, some audit activities, if there is no in-house Sharia audit board. And the next question is that who will be the eligible to be included in the Sharia board? And first of all, we see that what are the global practices, then we'll see that what are the guidance provided by Bangladesh Bank. So it has been mentioned that the individual should have degree in Fiqh Muamalat. Fiqh Muamalat. Okay. Can anyone mention what we mean by Muamalat? What Muamalat encompasses? Anyone, please come forward and share your understanding. Is it kind of Sharia guidance on how the individual has to maintain his relation with his creator? Or something different? I see no responses. Can I call you by name? Ishtiaq? Are you there?
Sir, I'm here, sir.
Yeah. Did we mention Muamalat in the beginning of our class?
Sir, I joined in late today, sir.
You joined late. Okay. Let me call another. Tasnuba? Are you there? I see one responses. Yeah. Tasnuba, please unmute and share what you have understood that by the term Muamalat. How it is, your mic is not working. Okay, that is unfortunate.
Sir, it is actually, sir, the
Hmm.
civil acts
Hmm.
which are not ibadat, but
Hmm.
these follow the religion properly, actually.
Okay. First of all, it is these are the rulings of Sharia.
Yes, sir.
These are rulings of Sharia, and these are related to man's relationship with his creator or man's relationship with other men. If it is man's relationship with creator, in that case, it will become ibadat, not muamalat.
No, sir, it's other men.
It's relationship with other
How
men.
to do business, commercial, like
Right. How
following
to
the
do the worldly activities, how to do the ordinary general activities, right? Okay. How
Yes,
to
sir.
lead the worldly life. Okay. So this part is muamalat. And fiqh is something what we mentioned that the knowledge of Sharia, the knowledge of Sharia is called the fiqh. Okay. So fiqh actually deals with that how the Sharia ruling, what are the Sharia rulings on these issues, and what are the Sharia rulings? Okay, exactly, precisely it is. Sharia rulings is known as fiqh. Okay, so you probably have heard about mufti. Have you heard about mufti, the term?
yes, sir.
Someone recognize
Personally,
them as
yes.
mufti? Okay, so mufti are the Islamic scholars who are expert in fiqh. Okay, so these are not the people who say something as like muhaddis, for example. So muhaddis are something who are expert in hadith. Okay, they are not expert in Sharia rulings. Okay, then there are some expert who have expertise in tafsir. Okay, so they are not expert in fiqh. So the people who are expert in fiqh, they recognize themselves as mufti. Okay, because they have learned the fiqh during their undergrad and postgraduate degree. Okay, so you know that we have some majors. We have majors: finance, banking, sociology, then physics. We have some major. So it is also possible to do some major in undergrad and postgrad in Islamic school or Islamic universities. Okay, so in those universities you have the option to specialize. So what are some areas in which you make a specialization? So some areas are fiqh, Some areas are tafsir, some areas are hadith. Okay, there is another area right now I can't recall. Okay, so we are here, we are concentrating on this, we are not concentrating on this, or we are not concentrating on this. Okay, you have to have a clear understanding of the Sharia ruling, and you have the knowledge to use your judgment to apply that Sharia ruling in a given context. Okay, at the same time as our sources of Sharia, Quran, Hadith, these are in Arabic. That's why the language competency in Arabic is extremely appreciated and extremely required, in addition to the competency in English. At the same time, the scholar should have, which scholar? The scholar who will be part of Islamic Sharia Supervisory Board. Okay, they should have knowledge of commercial law and finance. Okay, so then they should have previous employment and reputation. You see, this is not a very easy job. It is not a very easy job. You need to have a multifaceted knowledge. Okay. At the same time, I will show you that what are the requirements in Bangladesh. I mean the guidance set by Bangladesh Bank, and they are, I mean the individual who will be part of the Sharia Supervisory Board, they may be recruited as permanent, or they may be recruited on ad hoc basis, and they will be paid in this way. They'll be paid accommodation, hourly remuneration, or retention fee, these things. Okay, so before looking at the procedures for Sharia board meeting, let's have a look at what Bangladesh Bank is saying regarding the guidance of forming the Sharia Supervisory Committee. You see this appendix 1, right? Are you seeing my PDF file?
Yes, sir.
Okay. Remember we learned these guidelines in previous class. Okay. So there was a mentioning that they have mentioned the criteria of the members of Sharia Supervisory Board in the appendix 1. I probably may have mentioned this. Okay, that what are the criteria for selecting members of Sharia Supervisory Committee. So let's look at those criteria which have been set by Bangladesh Bank. Okay, you see, the member of Sharia, first of all, educational qualification. The member of Sharia Supervisory Committee must have the following qualification. They should have Kamil or Dawa or postgraduate degree in Islamic studies, Arabic, Islamic law, Islamic economics, Islamic banking, with profound knowledge in Arabic language. Okay, we see the things common we just have seen. Okay, now experience must have at least 3 years of experience of teaching or research work in Islamic jurisprudence, Islamic law, Islamic banking related subject. Next one, 3 years of experience as a member of any Darul Ifta or Fatwa board in giving Sharia rulings of Islamic trade and commerce, banking and financial matters. Have you heard about this board in our country? We have some Fatwa board, and there are members of these boards, and the incumbent of the Sharia Supervisory Committee must have 3 years of experience of working as a member of this board, and providing he has the practice, or sorry, he has the experience of giving rulings on Islamic trade and commerce, banking, and financial matters. I mean, that board in which he worked, that board was responsible for the Sharia rulings for these issues. And you see, publication of 3 executive exclusive articles on Islamic trade and commerce, Islamic banking, Islamic economics, Islamic commercial jurisprudence in any recognized journal, or publication of 3 books on the same subject. And this is huge. These requirements are actually huge requirement. Okay. Okay, let's look at the remaining. Track record. He must not have any passable track record in social, economic, and financial dealings. I mentioned must not have passable. That means must have an impassable track record. That means he didn't do something bad in these dealings, something unfairness, okay, something sinful in these dealings, okay, and has not been terminated or dismissed in the capacity of an employee or director, chairman from an institution, firm, or company. Then solvency. You see, this is interesting, that other than having knowledge, he has not been involved in any illegal or improper activity, particularly relating to banking business. At the same time, he has not been in default or payment of dues owed to any bank or financial institution, or default in payment of any taxes in individual capacity or as proprietary concern. You see, these things are interesting. At the same time, it provides the ground that how strict the requirement is in Sharia compliance guidelines. I mean, the people who will be in responsibility to look after the issue that their institutions are complying with the Sharia, there must be some person who are not impure. Okay, that's why you see that all dimensions are necessarily covered. Okay, then integrity, honesty, and reputation. Has not been convicted in any civil, criminal offense, or involved in financial impropriety, proprietary, and moral turpitude. Then has not been subject to any adverse findings in any settlement in civil, criminal proceedings, particularly with regard to investment, financial, business misconduct, and has not been contravened any of the requirements and standards of regulatory system or the equivalent standards of requirement of any regulatory authority. And finally, has not been diverted from giving religious rulings by any religious institution body. Divert from giving religious ruling. Any particular religious institutional body, if they declare that this person is not eligible for giving any religious ruling, in that case, that person is incapable of being included in the Sharia Supervisory Committee. Are you happy with this criteria set by Bangladesh Bank for forming the Sharia Supervisory Committee? I mean, for appointing the members of Sharia Supervisory Committee, or you feel that some things are missing? What do you think, based on the things what we have learned and what we have seen in application? Any response from you?
Sir, it's already very simple.
One by one. I couldn't hear anyone. Okay, please respond.
Sir,
The
it's
requirement
already
set
very
by
simple,
the
sir.
Again, two people are talking together.
with the requirement set by the Bangladesh
Bang. Then
Bank is sufficient, and that the member of the body is free and fair.
okay. Then second response. second response, someone was responding together.
Sir, hello.
Yeah.
Yes, sir. I think that both the management guidelines also both cares about the educational side and also the religious side. So I think it's enough.
Okay. Now, what is your responsibility? Your responsibility that when you are doing your term paper work, you are cross-checking that what is expected from this Islamic bank or Islamic financial institution and what is actually happened. So what you can add, I'm giving it 1 point, that you will look after the composition of Sharia supervisory board, and you will look at the qualifications of the member who are working in the Sharia supervisory board, and you will see that where there is a lackings of the member from the criteria set by or guided by Bangladesh Bank. Okay, so you can look after those issues. Okay, next thing that what can do, these are some general thing that how Sharia board will conduct their meeting. Okay, they'll determine their agenda, and it is the usual practice of meeting, and they will also approve the minutes of previous meeting, make actions and follow up. So you know the minutes of previous meeting is the decisions taken in the meeting are summarized in minutes. Okay, and also make minutes for current meeting and make assignment of necessary tasks to the responsible persons. Okay, now you see one interesting thing. Majority is not a thing which is preferred in Islam. Majority thing is preferred in common law and civil law. So in Islam, the rulings of Quran and Hadith, and also if it is from Ijma, if these are accepted and these are unanimous among minority, in that case, we should accept it. We should not wait to see whether majority is voting for it or majority is voting against it. So it is not an issue in the Sharia compliance. So I mean the Sharia guidance that you should look at what majority is doing. Majority might be doing something which is wrong in the eye of Sharia rulings. So there's a clear guidance that majority should be prioritized less relative to the guidance of the Quran and the Hadith. Okay. Then Ijma is the consensus of opinions, and here it is the practice that if there is a consensus among the members of Sharia board, it has been termed as Ijma, but at the same time the Sharia board is giving their member to veto, make veto against the opinion made by the board, and at the same time it is the responsibility of Sharia board to allocate the work and make the planning, and these are some routine activities, and it is the practice that on a frequent basis you have to interact with the financial professionals, because most of the financial practices need to be learned from these people to learn these things in a clear way. And these are duties and responsibilities of Sharia board that they always look at the new financial contract I mentioned. I mentioned the new product, new services, okay? So it is their first responsibility that before introducing the product to the customer or to the client, the Sharia board needs to review the new financial contract. Review for what? Review for the Sharia compliance. And make liaison with Islamic financial institutions, legal team, and external firms for drafting contract. And also, if these are for new things, okay, and there are some existing things. So sometimes it is observed that initially the institution was complying with the Sharia, but over time the Islamic financial institution is not complying with the Sharia, and they are making complaint that it is not possible, and there are these are challenges, and we cannot do this. If we have to continue this, we have to compromise the Sharia bindings, these things. So that's why over time, it might be the case the current operation is in violation of the Sharia compliance. In that case, it is essential to monitor time to time that the current operation of Islamic banks and financial activities, banking and financial activities, are in compliance with the Islamic Sharia. Okay. And for the investigation purpose, what can they do? They have to, this is a revolving knowledge. Fiqh Muamalat is a revolving knowledge because new issues are coming. Say, for example, derivative. Derivative, there is a debate. You probably have learned about the derivative, right? That whether derivatives should be allowed in Islamic financial market or derivatives should not be allowed. So there are some debate. There are support against, there are support for introducing financial derivatives. There is also Islamic financial derivatives, and there are also objection against the introduction of this kind of financial derivatives or permissibility of financial derivatives. Because you know very well that there are some issues, there are some issues of, on which the Sharia can raise question. So derivative is not a trending issue nowadays. Okay. And what can you do? You can look at that what the authors are concluding in articles, journal articles regarding the permissibility of financial derivatives in Islamic financial market, what they are concluding or what they are saying, or which financial derivatives are allowable, which financial derivatives are not allowable. Okay. Say, for example, commodity future. Commodity future is one particular thing which is mostly Sharia compliant. Commodity future. You probably can recall that we talked about a product in the investment class, I mean the Islamic investment class. I can recall the exact term right now, where Islamic banks purchase product with the deposits of the depositors, and they sell the products at a higher price later. So Islamic banks can use the future contract to purchase this commodity and also to sell the commodities at a higher price with the expectation of getting higher price later. But there are some other derivatives, say for example, what should I say? Say call option on equity. In that case, you will see there are a number of questions from the Sharia that whether it should be allowed or not. So absolutely, it is not a such case. It is not a such thing that all financial derivatives are Sharia incompliant, or all financial derivatives are Sharia compliant. So some products are Sharia compliant, and some products are not Sharia compliant. So Sharia board can work on the issue to check that which products can be allowed to float in the Islamic financial market or cannot be floated. And regularly they examine the fatwa by other Sharia committee, and they look at the published ruling by Fiqh Academy, National Sharia Board, if any, and London-based Institute of Islamic Banking and Insurance. I will mention about some global institutions who are guiding the Sharia supervision across the countries. Okay, so you see which institution I have mentioned as National Sharia Board in our country. Can you recall? I mentioned one authority. Let me show you their site. Okay.
Yes, sir. CSBIB, sir.
Yeah. So time to time, what they do, they issue rulings. Okay. They issue some rulings and they provide guidance, and they provide some update on their opinion, what they mentioned earlier. So yeah, they need to follow this. I mean, which authority? The Sharia board. Okay. So Sharia board has to regularly follow these rulings made by the Sharia board and also Fiqh Academy. Okay. Next, they also are in the position of issuance of fatwa, and they issue fatwa with detailed justification, and it is the responsibility of Sharia board or internal Sharia control department in using minutes as basis for explanation. And if there is any concern with consistency with other fatwa, they also have to check it. So what mechanisms they can follow? They can look at the statements in annual reports for compliance, and they can also look at web materials on Sharia board composition and rulings. And they can also outreach the activity by Sharia scholars. And I'm not very clear that why they have used the outreach term here. Outreach term, I do not know whether you are familiar with this term. Anyone? I just like to know your concept before I give you the idea that what we mean by this. Anyone familiar with this term, outreach? Other than the Islamic finance and banking, I'm not asking about with relation to our course. Anyone familiar with this term?
No, sir.
Okay. So this is a term used in the finance industry and also economic environment popularly to count the number of active borrowers, number of clients to whom you have been able to reach. They say number of active borrowers, particularly in microfinance. It is very popular term that how you have been able to improve your outreach. Okay. So this is not relevant here. here it has been used in different way. Okay, I was saying that I will introduce you with some Sharia board who work in global scale, and I'd like to particularly emphasize on this Islamic Financial Services Board, IFSB. Okay, say for example you work in Islamic Bank Bangladesh Limited, so your product department has designed a new product that you want to launch. This say for example Khidma credit card. Okay, but you are in a confusion that whether this will be in compliance with the Sharia or in compliance with the Sharia. Okay, so your Sharia supervisory board has given approval and has provided the fatwa that this is this kind of credit card is allowable. But at the same time, what you need to do, you need to take approval from the IFSB, Islamic Financial Services Board, that I am planning to launch this kind of credit card, whether you approve it or not, because they are the international body for setting guideline and standard for the regulation of Islamic financial institutions. So regularly you have to, I mean the very product department needs to have a very close connection, very close monitoring and very close reporting with the IFSB regarding the initiation of new product or issues with the existing product or non-compliance of existing product, or discussing the possibility of issuing new investment which has become popular in the conventional financial market, but you are in interest to issue this product in Islamic financial market. So globally, all Islamic banks, Islamic financial institutions, most of the Islamic banks and financial institutions regularly are in contact with Islamic Financial Services Board. So for your convenience, what can I do? I can show you their website. So you can follow their site and you check that what they do and what is their responsibility and what kind of standards they set. And this is their site, ifsb.org. Okay, and they conduct regular meeting and they have their own board. And this is an international standard setting body for Islamic banks and financial institutions. So if you are in interview board at say for example Islamic banks job, in that case it is very likely that you will be asked question whether you are familiar with IFSB. Okay, it is very unlikely. Then there is a audit board which set a standard for auditing and accounting organization for Islamic financial institutions. This is known as AAOIFI. Then you are much familiar with IDB, and I mentioned about it in one of our earlier classes, Islamic Development Bank, which provide Sharia compliant assistance, development assistance, particularly in the countries which are the member of OIC. And I mentioned that the Sharia Supervisory Board are in contact with Fiqh Academy, and we are mentioning two recognized Fiqh Academy in the world. One is OIC Fiqh Academy, which is representing 57 Muslim countries, and another popular and very well recognized Fiqh organization, I mean Fiqh issuing organization, I mean where people learn about Fiqh and take higher degrees on Fiqh. That is the Al Azhar University in Egypt, which is the oldest center for Islamic scholarship. Okay, and national Sharia law is not enacted or is not issued in our country yet. We do not have the separate act for Islamic banks and financial institutions, and that is the big challenge for us for which Islamic banks are in question from the people and from different stakeholders, because we do not have any national act for the Islamic banks and financial institutions. So that is all about for today's class. Let me